Good morning, class.
Morning, madam.
Sounds clear, ka? Volume okay, ka?
Yes, madam. Okay.
Okay. Today we're going to discuss question for civil procedure. You all nampak tak? Ni I share ni nampak tak? Ada tak? Question. Okay, question ni I dah share dalam WhatsApp. Boleh baca tak question ni? Kena nampak tak? And please somebody read question 1. Perdana, this is H1. Okay, part A, 10 marks for this part A. Can please somebody read the question?
I can read, madam.
Yeah, please.
Mona binti Abdullah seek your legal advice relating to a tragic death of her sister, Mariam, 42, who died due to collapse of a bridge at MR2 highway. The incident occurred on 3rd March 2021 at 5:50 p.m. opposite the Terminal Bersepadu Selatan TBS in Bandar Tasik Selatan. Mona informed you that the deceased was a single mother and worked at a factory to raise her two children aged 15 and 13 after her husband passed away. Her sister was on the way to work when a bridge collapsed and crashed onto the factory van she was in, and she died at the scene. Both of the children are now staying with her because she is the only relative that they have. She fears and worries for the future well-being of the children and would want the people who caused the incident to be responsible. Mona also informed you that the video and photograph of the incident has... Can you scroll down a bit?
Yeah. Sorry.
Has gone viral in the social media, and this may affect the state of mind of the children who are still grieving. Mona also showed you several newspaper cuttings reporting on the incident. ABC News reported the initial finding of the Kuala Lumpur Traffic Investigations and Enforcement Department. The Chief Assistant Commissioner said initial investigations revealed the incident is believed to have been caused by a lorry, one loaded with an excavator as its cargo, that crashed into the ongoing construction site. This finding was also affirmed by the Kuala Lumpur Fire and Rescue Department bomber and the Cheras fire stations who were at the site. Another newspaper, the Daily News, reported that police investigations revealed a trailer which was transporting an excavator collided with a pedestrian bridge steel frame at the construction site, which is Sungai Besi Ulu Kelang Expressway, at around 6 p.m. They also published a photograph of the incident showing a van underneath the steel scaffoldings. The news also revealed that the driver of the trailer had lodged a report at the Sungai Besi police station, and the police has apprehended him for further investigations for reckless driving. It was later revealed that the driver was driving under drugs influence where traces of methamphetamine was found in the urine sample of the 40-year-old driver, and accordingly, he was arrested and will be remanded. There was also a statement that the highway concessionaire, Suki Senjaberhad, in charge of the elevated expressway project, said the accident occurred when an overloaded trailer crashed into a scaffolding at the site, but denies any affiliation with the trailer driver. According to them, the trailer was not involved in the construction of the highway, and in fact, he was driving a private vehicle when the accident occurred. Nevertheless, an issue was highlighted in regard to the safety of the project since a similar incident occurred a month ago where a crane toppled, killing 3 workers and injuring a public. PV newspaper also reported on the incident. They have interviewed a resident who lived near the incident location, Amir Salim, who said he heard a loud sound like a thunder when he was at home before seeing the construction structure collapse. He further said, after seeing the falling bridge, I rushed to the location and found many people had gathered there, some taking video and photograph of the incident. The accident also caused a 2 kilometers long jam as the crash happened in the middle of the road.
Okay. Based on the above information, Mona wants to know the following. Okay, we look at the question again. So here, the disease is Mona's sister, right? Age 42, and she's working in a factory. Okay. So the parties here is what? Mona and sisters, the disease, the trailer driver, and the parties who else? Okay. And then the you see here the evidence will be the police report and photos, also the news, media social. Okay. So Ahmed Salim is the resident in the neighborhood. So based on the above information, Mona wants to know the following. Number one, what can she do and how can the law help her and the children of her deceased sister to continue living and have good education? 1.5 marks for this question. Okay, who's going to try to answer? What can she do and how can the law help her and the children of her deceased sister to continue living?
Claim for damages.
Claim for damages. So claim for damages would be the remedy, right? Claim for damages would be the remedy. So what are cause of action of this claim? Claim for damages against whom?
The driver.
Muhammad Zulkarnain, is it? Okay, claim for damages against the trailer driver. So this will be the topic will be under parties, right? Who's to claim? So the plaintiff will be, who are you going to name as the plaintiff?
Mona.
Mona. Mona, you can name Mona because the sisters, this is already, right? And the children still underage. So you name Mona as what? Legal representative. Right. Check order check order 15, rules of court. Titles regarding the parties. Claims 4. This is we under order 15, right?
Yes, madam, of order till 15.
Okay, order 15. So claims by Mona against the trailer driver. If trailer driver, how do you get the names of the trailer driver? When accident occurs, normally people make a lodge a police report. So what you should do is you to get a police report regarding the accidents. You put the accidents between whom and whom, the parties, at which place, at what time. Now you write to the police, they can get the reports, all the relevant reports regarding the accidents. And then you can decide how you're going to name as defendant. So by Mona against the trailer driver. And then what can she do and how can the law help her and the children of her deceased sister to continue living and have good education? So here when you say it's Mona, you have to explain why you have to name Mona. See? So you must cite the relevant provisions or the 15 here. Even though the marks will be 1.5 only, but you have to cite the names Mona, give a reason why, then under what provision, and then against the trailer driver. But trailer driver is one of the parties that you can name as defendant. But sorry, okay. But there are other party also here, other than the trailer driver. There's another parties involved here. Another newspaper, the Daily News, reported that previously that excavator collided. This one also. Okay, so you for the question number 1, you mentioned Mona. You cite Mona's name as plaintiff. The reason being, the children is underage, and then claims against the trailer driver for damages because negligence. Then you must quote also negligence on the part of the reckless driving. Okay, so that will be for question 1 here. 1.5 marks here. Okay, then we proceed to question number 2. Who would be the possible party or parties to be sued? Parties to be sued. That means the defendants. And what will be the reason for suing? Reason for suing. A, there are three. Question number 2, you must answer 3 parts here. Number 1, the possible parties to be sued. Number 2, the reason for suing. And 3, what challenge they may face in commencing the suit. 1.5 marks only, but 3 parts you have to answer the question. So, okay. Who would be the possible parties for to be named as defendants here? So the question, the possible parties to be sued. Siapa? Anyone? Muhammad Hairul?
Yes,
Possible
yes,
practice. Yeah.
madam.
Yeah.
Can
What
I
will be
see
possible?
the question above?
I mean the scenario, the
Yeah,
facts.
the scenario, yes.
I don't know. You can check your WhatsApp also. I share in WhatsApp.
Oh,
Also,
okay. Wait, madam.
okay. I try to reverse quick. Take some time to.
Okay.
Name of the defendants.
Is it Suki Sendambahat, madam?
One is Suki Srinambahat.
Yeah.
Suki Srinambahat is the artist who.
Who is sued?
Okay, one. Defendant, right?
Defendant, madam.
One is Suki. And then?
And then the plaintiff, of course, Mona.
No. The question is only the defendant.
Only defendant.
Okay. One is the Suki Construction Company lah. Who manage the construction. In charge of the elevated expressway project. Okay. Suki Srinambahat. Okay. And then? What about the trailer driver?
Oh. Yeah, trailer driver.
Trailer driver, and then when you name trailer driver, it's not a suffice. You must remember our deep pocket theory. Who's going to pay for claim? If you claim for damages, who's going to pay?
The
Insurance company.
The insurance company, yes.
Okay, the insurance company means you must sue the registered owner of the trailer.
Saya syarikat lori itulah, madam.
Yeah, syarikat lori. We assume because it's not stated here, so we just mentioned that the trailer driver, because we don't have the name, and the registered owner of the trailer.
Okay.
Okay. If you sue the trailer driver, of course, now if the court allow the claim against him, he cannot pay the damages, right? Unable to pay. So you have to name the registered owner, and then you can claim against. The insurance company is not named in the suit. Just put defendant, the registered owner. But later the solicitors for the defendants would notify the insurance. The procedure for claims regarding the motor vehicle accidents, collision, we have to give notice to the insurance company regarding the claim. You do search with JPJ, then is issued a report, then you can get the name of the insurance company, then you give notice to the insurance company, and give notification that you are filing summons against the registered owner, and the driver. Okay. So that the defendants will be 3 defendants here: Suki, trailer driver, and the registered owner of the trailer. Okay. So that's answer the first part. Second part is what would be the reason for suing? Reason for suing. What will the reason for suing?
Saya ke Mida?
Orang lain tak nak jawab ke?
Okay.
Nah, it's okay kalau Muhammad Khairul, you can proceed. No, orang lain tak mau, you can proceed. You dapat markah apa? Tadi dapat dah 1.5. Okay. Yang first part. And then the reason for suing?
Negligence.
Negligence, reckless driving.
Negligence.
Negligence, reckless driving, negligence. And then for register owner, because he's the register owner, right? And then the Suki Siam Bahat ke?
Suki Sinabak, betul mana?
Suki Siam Bahat. Because they are the parties who supervise, who control the project, kan? Contoh. But this one, Suki tu different part of the accident. Kalau you mention the other two parties yang trailer driver, register owner tu, that yang tu pun cukup dah, no? Okay, we proceed yang part 3, no? What challenge they may face in commencing the suit? Halangan dia. What challenge? If you are suing, you're claiming for damages, you kena buat apa? There must be proof, evidence. Right? What challenges they may face in commencing the suit? The challenges here is the question of evidence, how to prove the collision. Sebab dia Mona sisters died on the at the place of the collision. So you don't have witness. So quite challenge here, you have to apply to the from the police and then the Suki construction. That would be the problem. But how to overcome the problem? For the plaintiff, how to prove the negligence? How you're going to prove negligence? For the, you're waiting for Mona. So how are you going to prove the negligence?
Viral video tu, madam?
Ya, Nodalila.
Guna video and photograph yang gone viral in social media as a
That
proof.
should be the itu boleh. And then when you draft, you do your pleading, you draft the statement of claims. What are the very, very important principle yang you have to plead? You kena plead in your statement of claim.
Duty of care.
Duty of care.
The elements, madam, untuk fulfill the negligence.
Okay, duty of care. Okay, that's negligence. But here, if you go through the facts, there is no eyewitness, right? So if there's no eyewitness, you must plead this principle. There's one principle. What's that?
Benda.
Apa benda? Latin words.
Res ipsa loquitur.
Yeah, correct. Res ipsa loquitur. This one you must plead in the statement of claim, saying that the facts speak for itself, because what you have no eyewitness. Suddenly Mona is is traveling in the van suddenly, bukan Mona, no, Mona sister, traveling in a van suddenly collided, and then died on at that collision, died on this place of accident. So you have to play res ipsa locutor, you know. So that would settle the challenge here. Res ipsa locutor. So the burden move to the defendants to explain the explains the no. Okay. And then for evidence, like Dalila answered just now, the evidence you can use the video, the news. You can use that as evidence. Okay. Move to question 3. When can a case or an action be filed? Bila? When can a case or an action be filed? Are there any limitation period governing cases such as this? And one, part A now, here, when to file the action. Part 2, question is, any limitation period? And then, part C, how long will it take and what are the litigation process involved before the case could be settled? What are the litigation process? The litigation process involved before the case could be settled. 2 marks here. Okay. So, would like to answer this question 3?
Madam, I can try.
Yeah, please.
I think for when a case or an action can be filed.
Yeah.
So if for negligence, it's upon the occurrence of the damages. And if for the personal injuries, I think after the day of the accident, the start of the commencement date that we can take an action.
Hold on, Shakina. The first part, what? Negligence.
After the occurrence of the damages, that means the day after the accident, madam.
The day after the accident. When can a case or an action be filed? So when questions like this, you must know the limitation, the time frame for filing claim for damages or civil claim. These ones, you have to refer to the Civil Law Act. So what are the time limit to file action? This one's is claims for the disease. For the disease, you must, I think, you have to check the Civil Law Act. Please check Civil Law Act. If I'm not mistaken, you have to check. No, I haven't checked also. You check Civil Law Act. If I'm not mistaken, the time limit when for the disease plaintiff, would be 3 years. But you have to check. Please remind to check this under Civil Law Act.
Madam, is it 3 years or 6 years, madam?
I think, if I'm not mistaken, it's 3 years. 6 years for the negligence claim, yes, but this one when it's involved a disease plaintiff,
Okay, madam.
death claim, it's different. 3 years from the date of the collision, because this disease died at the because of the collision, on that date itself. So it's be 3 years, but please check with the Civil Law Act. So you can file the action after gather all the documents. You have the facts to draft the summons and statement of claim, and then file it within 3 years. No, if I'm not mistaken, we have to check this Civil Law Act. No, that should be the answer. Anytime before time lapse. That means, because for claims regarding negligence, vehicle accident, so you have to prove the negligence. For negligence, you have to get the police report, the sketch plan, all that, and then for the injury, you have to get the medical report, everything from the hospitals. And then for expenses, you can get from the from Mona who arrange for the funeral, everything. Then you can get. Yeah. So it would take some time for you to prepare the documents to draft the statement of claims. Then, meaning you cannot file on the following day, just like that. It will take some time. So, but you have to file the action within the frame, within 3 years, if I'm not mistaken. Double check that.
Betul, madam. Dah check.
Huh? Dah check.
3 years, within 3 years.
Then in that case, just to remind you all, on the exam date, please bring the rules of court and Civil Law Act. Ada ke Civil Law Act? Just in case a question, relate to something like this, and then you can refer to the Civil Law Act, the statute. And then, are there any limitation period governing cases such as this? So this next part of the question. So the limitation will be 3 years. So answer this part also. Okay. How long will it take, and what are the litigation process involved before the case could be settled? This is a question before the case could be settled. Quite general, this part. The case could be settled. Okay. So you better check case management regarding this case management regarding the claim for vehicle collision negligence. There are special rules regarding this. You can file the claims in the sessions court. Can somebody please check 34 pre-trial case management. Okay, automatic direction in personal injury action, order 34, rule 10. So this is a special provision for this type of case. So you must state the relevant provision, order 34, rule 10 here to answer this question. How long will it take, and what are the litigation process? So the litigation process will be what? One is filing the summons statement of claim, and then you serve on the defendants, and then you proceed with automatic direction in personal injury action. Okay, order 34, rule 10. And then after that, set down for trial. Then proceed with the hearings and then decision. So that will be the litigation process involved, right? Filing summons, and then the reply to defense is any. This one you are for the plaintiff, right? Filing defense for the reply to defense if any, and then comply with automatic direction in personal injury action as provided under Order 34 Rule 10. Then proceed with the trial. But during the process, when you exchange document, there's a situation where the insurance company, the defendants, make an offer for settlement. But if the plaintiff can, agree to accept the offer, then you can record the settlement before the hearing date. Okay. So that would be the answer for question 3. Okay, we move to 2 marks only for the question 3. For me, this question are quite complicated now. Okay, question number 4. How to stop the circulation of the video and photograph of the incident by the newspaper and in the social media by the bystanders. This is the first part. Question 4, first part, how to stop the circulation of the video. Okay. Once against the newspapers and the other one is by standard. And then part 2, can this be done even before a case be filed? How? 3 parts, yeah, for 1.5 marks. Okay. How to stop the circulation of the video? Is it possible?
Through injunction, madam.
Injunction. Injunction against the newspapers.
Dia ada apa term dia court boleh order daripada kata media circulate benda-benda video fotograf, saya lupa lah. Kes Najib.
Yang tu kes Najib, yang tu kes dah start. Yang ni kalau kes belum start macam mana? Macam mana? Can this be done even before a case be filed?
Interlocutory injunction.
Interlocutory injunction. But, macam ni lah question ni. I kata quite tricky. How to stop the circulation of the video and photograph of the incident by the newspapers? How to stop? How to stop? That means Mona has to file an action. File an action against the newspaper, not against the trailer driver, against the Suki Senamhat, no. Only against the newspapers involved.
Madam, maksudnya dia akan buat 2 action lah Satu negligence,
2
satu
action.
Lepas tu
2
kalau
action.
dalam social media tu madam, satu lagi
Yang
action.
ni social media by the yang ni susah. Yang ni dia just notify the public that dia akan ambil tindakan untuk saman anybody yang share atau forward video regarding the accident.
So dia buat statement lah.
Statement macam tu saja.
Kalau macam kes Najib tu, rasanya waktu yang kata court, siapa nama? Syafi'i apply dekat court untuk daripada buat circulate
Yang tu during trial sebab kes Najib dia dalam proceeding dah trial dah. Dia dalam masa
bukan yang baru mula-mula tu.
No. Dalam tu saya tak ingat lah. Sorry. Saya tak ingat. Tapi yang ni saya ingat yang baru ni pun court ada komen juga sebab ramai ada bukan kes Najib saja, ada kes lain sebab social media sekarang ni ramai yang share. So jadi prejudis kan. Jadi selalu court remind dekat open court tu dalam proceeding tu lawyer minta ataupun pendakwa minta, so court remind public jangan share, jangan komen. Dan yang tu tak ada application formal. So against social media you just macam siapa Khairul tadi kata buat press statement, kata you akan sue atau you bagi, you notify public, you can take action siapa-siapa yang share, yang spread video ni. Macam tu lah kalau you nak saman bystanders, ni susah. Newspaper okay. Dua action, you file separate action against the newspaper for injunction only. No? So injunction jadi final order. Okay. That will be the answer for this part. Okay. Can this be done even before a case be filed? Boleh lah kan? Kalau dua action, you can file separate action before case be filed. So this answer this part also, this part too. How? File injunction and a separate, you file action against the defendants, trailer drivers motor, and then separate action against the newspapers and notify, macam warning to the bystanders not to share, not to spread the video and photograph. Okay. Question number 5. What kind of evidence can they rely on to prove the case against the defendants? So, evidence. Questions, what kind of evidence? Part 2, how to get them? How to get the evidence? And part 3, can they rely on the newspapers cutting? Okay. So what kind of evidence can be relied on?
Real evidence, objek punya evidence.
I nak underline ni tak tahu cari macam mana. Okay, what kind of evidence?
Macam madam tekan tu madam yang pensel tu madam nak highlight.
Mana? Ni ya.
Ya betul. Sebelah tu.
Ni. Okay. Okay, never mind. Evidence. What kind of evidence can they rely?
Madam, sorry
Ya.
madam. Tadi tu yang saya baru jumpa term dia gag order. Yang tu tak boleh pakai.
Get order. Yang mana yang tadi? Question ni. This one.
Yang untuk stop daripada media speculate benda semua.
Get order lah. Kita file separate action
Itu term dia lah.
So file separate action to obtain order untuk restraint injunction. Okay. So kita proceed number 5 nah. Okay. Evidence that can they rely. Yang ni what kind of evidence?
Real evidence madam.
Ya?
Real evidence.
Real evidence.
Artikel
Real evidence is it? What's the real evidence?
Recording tu.
Evidence. The police report. Police report. Tadi ada kan police punya investigation. So you can get the reports regarding the investigation, but you have to apply from the police lah. No? Police report, sketch plan, and then video, video and photograph. They can rely on this. How to get them? How to get them? For the police report, you can apply to the police. You can buy the report. No? To give the normally in accident cases, we write to the police. First, the parties who involved in the accident would lodge a report. Like in this case, Mona's accident, that somebody must have lodged a report. So you get the number of the report and you apply to court. And then in that report, the first information report, normally they will mention the parties who involved, the vehicle number, everything. And then following that, you can write to the KPJ for the details regarding the uh, lorry, the trailer. And then you can write to the hospital for medical report. And then for the video and photos, you can rely on that. And okay, this one to the evidence to be relied on to prove the case against the defendants. How to get them? Yeah, you write to the relevant parties. Can they rely on the newspaper cutting as evidence to prove the facts? Okay. Can or not?
Boleh kot madam sebab tu still evidence.
Yeah.
Boleh kot sebab tu still evidence.
Evidence. Boleh, boleh. Boleh tu boleh. But then during trial you kena tender dokumen tu, masa tu lah you kena pastikan. Kalau newspapers, which reporter yang involved yang buat statement tu, yang tulis tu. You kena ada tu. Tapi answer this question yang tadi tu okay dah. Evidence je. Medical report, video and photograph. What kind of evidence? And then how to get them? Write to the relevant parties. Then kalau dia refuse, you can get the court order. Discovery lah. This part is discovery. And then can rely on the newspaper. Can, provided you can get the source of the information. Like newspapers cutting, who's the reporter yang tulis tu. Okay. Well, that's answer question number 5. Okay. What kind of remedies can they seek from the court? Remedies. What kind of remedies? Remedies ni tuntutan lah. What remedies can they seek from the court?
Pecuniary remedies.
Pecuniary remedies. Damages lah. Pecuniary remedies, it means damages. You can claim for special damages and general damages. For the injuries, for the loss, here, the plaintiff is a disease. So the legal representative file claims for against the defendants for the disease plaintiff. Then for the dependents, there will be dependency claim here because the claims for the infants of the plaintiff disease. So there will be a dependency claim here. So plaintiff died on the spot, so there's a claim under bereavement to check the Civil Law Act, how much is the claim for bereavement. You can claim for here, case fatal accidents. So the remedies will be special damages for the loss incurred for the funerals, everything. And then for the loss of income, dependency claim, the check Civil Law Act. This one also under Civil Law Act. Dependency claim. You see, the disease is working. So the Civil Law Act, provide that the working age will be up to 60 years of age. So at the disease age is 42, right? So you take 60 minus 42. So the court will consider the loss of income, monthly income. No, that would be for damages for dependency claim for the infant. And then bereavement, because she died. You check on this because I haven't done accident claim for quite some times. But those days when I'm doing this type of cases, bereavements is 10,000 only. Those days. I'm not sure whether it's amended already. So remedies will be for bereavement, for dependency claim, and then for special damages and general damages. So you have to consider the loss of income because if not because of the accidents, he can proceed to works or not. You take the provision given under the Civil Law Act, the working age is up to 60 years. So she can work for how many years more? 18 years more. So you time the monthly income of the disease. So there will be the loss of earning for dependency claim. So the infant is denied of that. So you can claim that as remedy. Can the court award any remedy even if the parties did not plead it? Boleh tak? Can the court award any remedy even if the parties did not plead it? Boleh tak?
Boleh, madam.
Boleh.
Tak boleh kot.
Tak boleh. No, you must plead remedy dalam statement claim. Like dependency claim, loss of income tu, you tak claim, court tak bagi. Unless you claim dalam masa hearing tu, defendant solicitor diam, tak object, then boleh lah. No? Tapi kalau normally, defendant solicitors akan object lah. No? Kalau dia object memang tak boleh proceed. Unless dia kena amend. Tu pun kalau court bagi. No? Advise Mona on the above issues and support your answer with legal authorities. Ini yang refer to this question number 6. What kind of remedies? Memang tak boleh. And then with legal authorities, you check case. Yang ni, kalau fatal accident claim ni kes lama dulu, kes Muhammad Amin tu lah. I can remember, tapi tu kes lama dulu lah. No? Ni. Remedy must plead remedy. Kalau you fail to plead, then court tak akan bagi. Ni ada case law on this. Semak topik pleading for this one. Do your revision on pleading. Okay, ada nak tanya dah sini? Any question? So far. Faham tak?
Faham, Madam?
Faham? Okay, kita proceed lagi. Okay, this one siapa nak baca? Please somebody. 12:24 already. Cepatnya. Somebody baca now. I share.
Saya boleh
Attendance.
baca, Madam.
Ya, ya.
Baca question ni je kan, Madam?
You baca dulu. So I share attendance. Sekali
Okay.
baca dulu. No, later lah kita share attendance, no? Kita
Aha.
habiskan ni dulu. Okay.
Okay.
Okay, proceed baca.
Okay, question 1. Perencana Global Sendirian Berhad instructed Mrs. Abraham and Tan to file writ of summons and statement of claim against Medi Pharma Sendirian Berhad for patent infringement. The writ of summons and statement of claim was filed on 20 April 2021. The document was extracted on 23rd April 2021 but was only served on the defendant on 4th May 2021.
Okay,
In the meantime,
hold on. Bila
Okay.
date involved, you have to remember this date, no? You mark ni. You baca question, you mark this date semua. Okay, proceed.
in the meantime, the defendant has appointed your firm to act on their behalf and to file the memorandum of appearance as soon as possible. Upon reading the statement of claim, you notice that the particulars in the statement of claim are not sufficiently specific, which cause you having difficulties to prepare the statement of defense.
Okay. Okay. Since, continue.
Since you are a pupil at your firm, your master asks you to prepare the following based on the fact of the case and legal authorities. How do you calculate the deadline for you to file the memorandum of appearance?
Okay. So question is memorandum of appearance. Service bila?
23rd, 4th May.
Was May. Service was May. So, how do you calculate? Okay, was May 2021. So, deadline to file memorandum of appearance bila? Was May? Deadline you ambil daripada bila? Following day kan? Lebih 5, 6,
Silap saya, Madam.
5, 6, 7, 8, 9, 10, 14 hari kan?
Madam.
14 hari kan? Kasi ambil 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, no? Kalau you kira tu, jadi 18 Mei. 18 Mei 2021. Okay. How do you calculate the deadline for you to file the memorandum of appearance? This one you refer to the relevant provision appearance. Itu ada. You letak jawapan tu support dengan provision. 14 hari following 4th May. Okay. Question number 2. One marks for that. Practically, what is the appropriate process under rule of court that you can use to issue in preparing statement of defense when the statement of claim are not sufficiently specific? What is the appropriate process under rules court that you can use to issue in preparing statement of defense when the statement of claim are not sufficiently specific? Hold on, So a problem that just this question. What is the process under the rules that you can use to issue in preparing statement when statement of claim are not sufficiently specific statement of defense? So claims under patent infringement. Defendant has appointed your firm to act on their behalf and to file as soon as possible for a statement of claim. You notice that the particulars in the statement of claim are not sufficiently specific, which cause you having difficulties to prepare the statement of defense. Okay. What is the appropriate process under the rules, given under the rules? So anybody? Statement of claims not specific. susah nak apa draft statement of defense. So what are the appropriate process? Okay. Siapa nak jawab? Faham question tak?
Faham madam question dia. Order 18 kot madam.
Ha?
Order 18 kot.
Order 18. Discovery lah kan? You document tak ada, kita tak ada document. You're going to ask documents from the plaintiff. Jadi apply for discovery lah, minta document. So actually if it happens like this, sometimes it's happened like this, we can write to the plaintiff solicitors to ask for the relevant document to be supplied to defendants, to prepare the statement of defense. Normally like what we used to do is just write a letter give undertaking that you are willing to pay the cost for photostating everything, and then ask for the plaintiff to give the copy of the relevant documents regarding the case. And then meantime, you write to court for extension date to file a defense. That would be the appropriate process lah. No? Sometimes now when you write to the plaintiff solicitor to ask for the document, then they realize the statement of claim is not specific, not clear, then they amend. Sometimes it happens like that. But you can write to the solicitors for documents, discovery, and then write to court for extension of time. Which time lapse, that means you have to file application supported with affidavit for extension of time to file a defense. So that's will be the answer for question part 2. Okay, move to part 3. Hafiz, can read this question, part 3. Ada kah Hafiz? Okay, anybody? No? Please read question 3, part 3.
Saya lah baca madam.
Okay.
Based on your answer in question 2, assuming that Moses Abraham and Tan does not respond to your request, what will be the next procedural step to take to enable you to prepare and file your defense within time?
Say, assuming you write to the Mrs. Abraham and Tan for a copy of the documents, but they does just not respond. So what will be the next procedural step is to apply to court for discovery. Application and affidavit for discovery. So that will be the next step. Enable you to prepare the statement of defense. And if you cannot get the documents within time, you file application for extension of time. So that would be the answer. You know,
And
this one is yeah.
jadi soalan nombor 2 tu order 24-27 kan. So yang ketiga dia nak apply to court pula kan untuk nak discovery kan.
Ya, ya.
Yang tu order berapa madam?
Discovery.
11 pula. Order yang soalan ketiga tu jadi order 24/11 ke? Bukan ni. Oh ni
For discovery of particular
12.
documents.
Order court.
Yeah.
Oh.
Huh?
Okay, terima kasih.
Because some solicitors, they are corporate. You know, normally we cooperate, but some solicitors are difficult. So, if difficult situation, you have to apply to court. Seek for court assistance. So you have to apply for court order. So that settles this question part 3. Move to question 2. On the other hand, assuming this one you are pupil. On the other hand, assuming you are working as a partner at Mrs. Abraham, you are at Abraham Tan, and you notice there are several mistakes in the statement of claim filed by your legal associate. What is the best procedure? Number 1, what is the best procedure to cure the mistake in the statement of claim prepared by your legal associate? Okay. So what's the answer? Anybody? Anyone?
The notice of application to amend the statement of claim.
Okay. Application to amend statement of claim. Correct. And that should be the correct answer. And then we mentioned amendments under order. Please answer that part also. Not in your answer, you must write the relevant order under order 20. No? Amendment, you just stay under order 20, that will do suffice. Assuming that, question number 2, assuming that the pleading has been deemed closed, pleading closed, how do you rectify the mistake in the statement of claim, and what is the best explanation to the court to justify the mistake? Pleading closed already, so what will we do? Pleading closed already, so you want to amend the statement of claim. It will be same procedure. You file application to amend under order 20. Explanation will be you just take over the file from the partners, or no, you have only obtained the documents. Now you have to give explanation to the court to just justify the mistake. So the requirement for application of amendment, you must read that there is a typing error, no, that the claims mistake is a mistake. And I have to explain the reason here under order 20. Amendment under order 20 rule, things that court should consider to give the order for amendment. Order 20 rule 5, no? Amendment of rate of pleading with leave. Amendment to correct the name party mentioned here. Under order 20 rule 5. have to support, you must give explanation in the affidavit. No, that would be the answer for question part 2. Okay, move to part 3. Assuming that there are numerous and major mistakes in your rate of summon and the statement of claim, what is the best possible procedure for you to rectify the mistake, major mistake? How to rectify? Mention here, numerous and major mistake. How to rectify? Siapa nak cuba jawab? Zul Hakim, boleh cuba? Numerous and major mistake in your rate of summon. Yeah?
Rule 10.
Rule
Order
10,
20, Rule 10 kot.
Order 20, Rule 10.
Rasanya lah.
Order 20, Rule 10. You baca? Tadilah, please baca. Order 20, Rule 10.
Modes of amendment of rate under Order 20 Rule 10, where the amendment authorized under any rule of this order to be made in a rate, reading or other document are so numerous or of such nature or length that to make written alteration of the document so as to give effect to them would make it difficult or inconvenient to read, a fresh document amended as so authorized shall be prepared, and in the case of a writ, reissued, but except as apostate and subject to any direction given under Rule 5 or 8, the amendment so authorized may be effected by making in writing the necessary alteration of the document, and in the case of a writ, causing it to be resealed and filing a copy thereof.
So this one, correct, no? Order 20, Rule 10. So let's be the best possible. Otherwise, some solicitors, they withdraw the action. Withdraw with liberty to file a fresh action. And that would be the last resort lah. No? Kalau dia dah masuk defense, normally defendants would ask for cost. Kalau you going to withdraw, they will ask for cost. Okay. Move to question part 4. Based on your answer in question 2 above, can the defendant file amendment to the defense if they have already filed their defense before receiving the amended document from the plaintiff? Boleh tak?
Boleh.
Boleh. No? Normally, kalau order for amendment given, the plaintiff will amend the statement of claim as per the draft amended statement of claim, then they serve on the defendants, and then the court normally would give the order for the defendant to file amendment to their defense, if there is a need. So you can file. Otherwise, it would be unfair for the defendant lah, kan? Okay. So question B ni, you can elect either to answer part A or part 1, B1 or B2. Can choose. So we proceed with B2. Okay. Somebody please read the scenario for question B2. Okay. Somebody please read. Cepat, kita tak banyak masa dah. 17 minit lagi kan?
Madam, can I read?
Yeah. Thank you.
Okay. Liam Engineering Sdn Berhad, LESP, is in the business of selling, marketing and distributing marine and industrial engines, generators and other engineering equipment and products. NOAA contractor Sdn Berhad and CSB is the main contractor of a project known as proposed construction of 3-story data center. The project. The employer of the project is Oliver Data Sdn Berhad. By way of letter dated 1 November 2018, NCSB appointed LESB as a nominated subcontractor to supply, deliver, install, test and commission and maintain installation services for the project for the sum of 20.5 million. The contract. Around 16 December 2018, NCSB paid LESB a sum of 2 million as down payment. Pursuant to the contract, LESB claimed that it had carried out works and had issued progress claims totaling 14,644,647.95. The progress claims were submitted to the project's mechanical and electrical engineer, Mary Consultant Sdn Berhad, and the architect, Julia Architect, for the certification of the value of work done. As at 16 October 2019, Mary Consultant Sdn Berhad and Julia Architect certified the value of LESB's work as 16,336,972.15. LESB claimed that a balance sum of 15,786,972.15 is now due and outstanding from NCSB. LESB filed writ against NCSB to claim for that balance sum. In its defense, NCSB denied that it is liable to pay LESB and that NCSB was the only person that could certify the value of work done by the LESB, since they did not approve the appointment of the architect.
Okay. Faham question ni? The two parties here, the contractor, Liam Engineering, LSB, and the subcontractor. Subcontractor is who? LESB. LESB is the subcontractor. And CSB is the main contractor. Based on the above facts and with reference to rules of court and legal authorities, discuss the following legal issue. Does the rules of court 2012 provide any mechanism to obtain a quick judgment? Briefly discuss the said mechanism. Quick judgment. So what's the procedure for quick judgment?
Summary judgment.
Yeah, summary judgment. Any mechanism to obtain a quick judgment, briefly discuss the said mechanism. So be the summary judgment. So you stated is be the summary judgment. But for summary judgments, there must be a clear-cut case or no issue, right?
Yes.
Here, any issue involved here. A week later, appointed this there's a letter here. Also, the contract, LESB claimed that it had carried out works and had issued progress claim totaling this one. The progress claim was submitted to the project mechanical, Mary Consultant and the architect for the certification of the value of work done. Question here. See here, NCSB denied that it's liable to pay, and then NCSB was the only person that could certify the value of work done by the. So this will be the issue here, no? NCSB denied because they are saying NCSB was the only person that could certify because LESB has appointed Mary Consultant and Julia Architect. So this one denied, liability because of this, and CSB denied their liability to pay. So there's a question of fact here. There's a tribal issue here. So the question, does the rules of court provide any mechanism to obtain quick judgment? So the answer would be the application for summary judgment under Order 14. You must mention that Order 14 because it's provision under rules of court. Okay, you move to question part 2. State the most suitable application that LESB can seek from the court in order to obtain the quick judgment, and explain the rules, procedure and the requirement that must be fulfilled for the application to succeed. Okay, apa nak jawab ni? Anybody like to answer? Dia bukan tanya menang ke tidak lagi, dia tanya nak kena buat apa je. State the most suitable application that SP can seek from the court in order to obtain the quick judgment. Summary judgment tadi dah jawab dah. So this one pun summary judgment lagi. Cuma further explanation. No? You have to explain why LESB entitled to claim for the amount for the summary judgment. No? Kena split dalam affidavit, there's no tribal issue. A clear case. Answer yang ni. But 4 marks for this. And then question number 3, what should LESB do once it has filed summary judgment application? File a summary judgment application, what should LESB do? Anyone? File then serve lah kan? You file summary judgment application, then summary judgment application is a copy issued by court, then you have to proceed with service on the defendant. That will be the answer for question part 3. Okay. On the other hand, assuming that you are acting for NCSB, what will be your argument against the application? And if NCSB wants to rely on a documentary evidence, state the manner on how the evidence can be produced in court at the hearing of application. Ini NCSB have to plead there's a tribal issue, needs to call the witness to testify in court. Then the tribal issue, no? Only then rebut the application for summary judgment, no? Support with authority, case law on this. On hearing the application, question number 5. Upon hearing the application, the judge allowed LESB application for the amount of 15,000 against NCSB. What should NCSB do if they disagree? Buat apa kalau tak agree dengan court order tu, court judgment? Okay, anyone? Nak jawab? Sebab kita nak habis dah ni.
Set aside.
Set aside application summary judgment.
Oh, mana boleh set aside? No, kalau dah court dengar hearing from both parties, tak boleh set aside.
Appeal for full
madam.
trial, madam.
Ha?
Full
Appeal.
trial.
Appeal.
Oh,
Appeal.
okay.
Kalau ni kena appeal, tak boleh set aside dah. Summary judgment is kalau the court dah proceed dengan both parties on merit, they will be considered as final judgment. Final judgment, there's no other option. You have to proceed with appeal kalau tak setuju. No, tak puas hati, you have to file appeal. Within the time frame. Kena sebutlah sini appeal within how many days? 14 days ke? This one would be appeal against the order other than the full trial. So we under 111A kan? This one. Okay. So kita cover this part saja. Sekejap. So kita check attendance lah. And then meanwhile ada I share dekat portal tu tajuk proceeding in chambers. You can go through the slide now. So stop sharing. Okay. Sekejap I share attendance. Mana pula? Sekejap. Okay, sekejap nak share attendance dah tak reti pula dah. Sorry student, take some time, Sekejap. Okay, scan now.
Madam, nanti soalan madam buat macam yang tadi ke madam?
Soalan saya, soalan yang saya buat tu tak complicated macam tadi. Yang tadi tu saya tengok complicated, you nak digest, nak faham question pun take sometimes question dia. Complicated sikit. Prosedur dia tak payah, tapi saya tengok question tu, dia punya cerita dia tu, fact dia tu payah.
Madam,
Ya.
soalan yang madam buat tu macam case ada banyak tak madam?
Saya yang senario tu saya ingat saya buat satu saja. Question yang saya buat, kalau saya buat tak payah.
Meaning to
Tak
say
tricky.
that
Direct question.
maksudnya madam the allocation of the marks tu macam kecil-kecil macam tadi ke ataupun is 10, 15 terus 25 ke?
Ada yang kecil-kecil macam tadi. Yang buat kecil-kecil macam tu lah.
Alright.
Jadi kalau
Thank you,
yang bagi banyak tu maknanya you kena jawab banyak. Kalau
Maksudnya soalan madam tak ada highlight madam?
macam mana?
Soalan madam tak ada problematik ke?
Ada. Law
Oh,
mesti
ada
ada
highlight.
problem. Tak ada problem orang tak mai jumpa lawyer. Dia mesti ada problem, tapi direct question. Saya tak tricky macam yang question yang lecturer tu buat. Tapi saya tak tahu dia orang pilih jawab soalan saya ke tidak. No. Sebab normally universiti semua pun dia ada bank of question. So dia orang akan pilih, dia orang Pilih yang question-question yang akan dicetak. Kalau soalan saya tu dipilih, insyaAllah tak payah. Direct question saja. No? Dia, kalau you faham question, sebab law dia provision dia tak ubah, dia macam yang dalam rules. Cuma you nak apply dengan facts tu, you nak faham dengan facts question tu yang jadi payah. Sebab facts tu dia tak sama. Macam question yang kita discuss tadi tu quite complicated, tricky. Tapi saya tak bagi question yang tricky. Direct question, senang faham jawab. No? Sebab kalau saya nak semua student saya lulus. Bukan nak bagi susah. No? As long as you faham, you boleh jawab tu, okay. Direct question you faham. Sebab bila you graduate, you keluar. Of course, yang fresh graduate, you punya pemahaman, you understanding tu limited. Yang tu you boleh dapat dengan experience apa semua. So, I punya approach, personally, I tak buat soalan yang susah, yang tricky, student nak jawab. No? Direct question. InsyaAllah you all boleh jawab. Provided you study, you do your revision. No? Macam question tadi, even though quite difficult, fact dia, tricky, tapi prosedur dia sama. Jadi kalau you faham question, you boleh jawab juga. You faham law, you faham fact, you boleh jawab juga. Tapi ambil masa you nak faham kisah fact yang dia bagi tu. No? Kalau question tadi you rasa payah ke tidak? You rasa payah ke soalan tadi?
Dia tricky sikit lah tu. Tapi
Dia tricky fact dia tu. No? Panjang dan banyak pihak, tapi you kena teliti bila baca fact tu. No? Kena tanda. Kalau you tak tanda, you tak take note point yang penting tu, memang payah you nak jawab. You kena tanda, kena mark tu. Which part? Parties, time, date tu, dia punya course of action, yang tu. Civil procedure dia itu je. Yang facts, issue, remedy, procedure. Yang tu je. InsyaAllah boleh jawab. No? Okay, dah scan semua ke? Semua dah boleh scan ke?
dah madam. InsyaAllah boleh jawab. Dah scan madam.
For final exam, final year you all 3 paper saja kan?
Madam.
Kalau tengok 3 paper tu rasa macam tak payah. Tapi bila saya tengok assignment 1, 2, quiz dengan make exam rasa macam payah. Tapi bila tengok 3 paper saja okey lah. Boleh lah, no? So, for assignment apa semua tu 60 marks. 60 marks setakat ni semua lulus lah, no? So, tunggu for final exam je. I share usually the grade before exam. Nah, tak habis lagi marking. So, all the best semua.
Madam nak add manually boleh?
Ya?
Nak add manually.
Finally, bagi nama WhatsApp, nah?
Okay.
WhatsApp bagi nama. Okay. Kehadiran semua clear dah kah? Check tak kehadiran, attendance. Semua cukup dah untuk exam? Nah, please check nah. I takut nanti tak boleh nak approve ke apa ke saya, no? Sebab saya first time saya join dengan UUM, jadi saya tak clear sangat prosedur tu. Saya nak kena go through apa semua tarikh-tarikh tu. Just to remind you, please, everybody please check your attendance, no? Just in case tak cukup, less than 80% ke apa, no? Okay. Semua dah scan, no? Bila semua dah scan, siapa tak sempat nanti check nak add manual, just WhatsApp dekat I sebelum I tutup, no? Okay, thank you, all the best everybody, take care, no? Make sure semua sihat No exam. Jaga makan semua. Okay. All the best. Enjoy your study.
Thank you so much, madam.
Thank you so much, madam. Have a nice
Thank
day.
you so much, madam, for the
Thank you,
class.
Bye-bye. Sorry sebab semua tak tunjuk muka soal tak kenal you all semua.
Saya
Okay.
bukan dah.
Madam nak ambil gambar, madam.
Okay. Thank you. Thank you.
Our
Ambil gambar.
last class.
Okay. Okay. Siapa nanti datang Alostar boleh stop by kat office I, no? Just dekat Pekan sini, opposite Pekan Rabu, same row dengan CIMB. No? Okay. All the best everybody. No?
We are opening our camp.
And then,
Sekejap, madam nak ambil gambar.
oh nak ambil gambar. Okay.
Madam, stop sharing, madam. Nanti nampak aku semua orang.
Oh. Macam mana saya nak? Sharing. Okay. Oh.
Anak-anak pusat pengajian undang-undang.
Okay. Okay, sekejap. Saya ambil gambar dengan semua, no?
Madam, selamat Hari Raya, madam.
Sama.
Syahrini.
Balik ke ayah semua.
Tak balik, madam. Study final.
Tak balik ya. Siapa yang tak balik? Berapa orang tak balik?
Ramai, madam.
Ramai ke?
Ramai tak balik.
Khairul Almas tak balik.
Failah tak
Oh.
balik. Mastura tak balik.